Hello and welcome to Amigos IAS. I am Adnan. In today's segment, we'll be discussing the significant or historic decision taken by Supreme Court 5-judge bench in the matter related to Article 370, the abrogation of special status to Jammu and Kashmir. So this was a 5-judge constitution bench which delivered the verdict. So in this, we need to understand certain issues. Firstly, we have to understand what was this special provision about, which was actually temporary in nature. And the second thing is, what were the arguments made by the petitioners in this case regarding the legality of the government's decision to remove this special status to Jammu and Kashmir. And then we will also see what the Supreme Court has ruled in this regard. So beginning with this aspect, Article 370 of the Constitution, India has a very different model of federalism where asymmetry prevails. That means not all states will be treated equally by the center. And in a federation, it is quite obvious that the units which compose the federation are not of same nature. So special provisions are given to different states in India. But Jammu and Kashmir's case is quite peculiar in nature because of its history. So what happened in the case of Jammu and Kashmir was Maharaja Hari Singh, who ruled Kashmir, had to sign the instrument of accession to India in 1947 because of the invasion by the Pakistan into Jammu and Kashmir. So as a result, India has put some conditions to Hari Singh regarding his instrument of accession. So in 1949, when the Constitution of India was still being written, we have incorporated Article 370 by adding the word temporary provisions with respect to Jammu and Kashmir. Why it was temporary? Because the Jammu and Kashmir was promised to have its own separate flag, their own constitution. Okay, and this constitution of Jammu and Kashmir will be framed by a special assembly called Constituent Assembly of Jammu and Kashmir. And this was formed in 1951. The Jammu and Kashmir Constituent Assembly wrote the constitution of Jammu and Kashmir, and it was disbanded in 1957 once the constitution was completed. Now here comes an interesting batch of arguments, like was this Article 370 meant to have special provisions for Jammu and Kashmir for permanent nature or for temporary nature? So let us first understand the basics of this Article 370. So here this Article 370, as we discussed, has given special autonomous status to the state of Jammu and Kashmir, and it was called temporary. And second aspect, the Parliament of India can of course make laws for Jammu and Kashmir in the matters of defense, foreign affairs, finance and communications. In the remaining matters, it is the Jammu and Kashmir Assembly which can make the laws. That means the control of the Indian Parliament over Jammu and Kashmir is limited in nature. And the Government of India has said that the people of Jammu and Kashmir, that means acting through their assembly, okay, who were finally able to determine the constitution of the state and the jurisdiction of Government of India. That means any modifications with respect to these special provisions shall be held in concurrence with the Jammu and Kashmir Constituent Assembly. That is the most important point here. Now, the applicability of the constitution, okay, regarding this state was accordingly in the nature of a temporary arrangement. And this was the substance of the provision embodied in Article 370 of the Constitution, as we have just understood. Now, in 2019, things have changed. That means almost more than 7 decades since this provision was enacted, the current government had removed this special status. That means technically the word abrogation of Article 370 is not right, because Article 370 is still there today. The only thing is the special status has been abrogated. So please let us understand the nuances of this particular issue. Fine. So let us now see what happened in this case. Timeline is more important for us. The Article 370 special status was not revoked by any constitutional amendment. It was done via the presidential orders. So there was Constitution Order 272, Constitution Order 273. We will understand this in detail. So just hold on for the explanation. So on August 5, 2019, the President Ramnath Kovind issued Constitution Order 272, okay, which amended Article 367, and it has given the chance that instead of asking the Constituent Assembly of Jammu and Kashmir, we will be taking the permission of Jammu and Kashmir Legislative Assembly. More on this, just hold on, I'll explain in detail. That means Article 370 abrogation, the special status was done not by amendment but by just a presidential order. Understand this segment here. And the second one is what? Within hours of this order, Rajya Sabha recommended that Article 370 should cease to operate since Jammu and Kashmir was in president's rule, okay, and the governor of the erstwhile state gets the power of assembly and parliament made the recommendation on behalf of the governor. So two things you have to understand here. One, Article 367 talks about interpretation of the constitution. Okay, Article 367 defines like what, because our constitution mentions a lot of things and how to define those things, it is mentioned in Article 367. That is one aspect here. Now Article 370 clause 3 says the president may modify or the president may change the provisions of Article 370 by taking the opinion of the Constituent Assembly of the Jammu and Kashmir. So the key word here is what? Constituent Assembly of Jammu and Kashmir permission is required. The president can actually revoke or modify Article 370. That means what? It's a destructive provision of Article 370 itself, because it talks about changing the Article 370 or removing of Article 370 can be done as per this clause by the president in consultation with the Constituent Assembly of Jammu and Kashmir. But as we understand, today there is no Constituent Assembly. In 1957, the assembly ceased to exist after writing the Constitution of Jammu and Kashmir. Now, who should give the permission? The petitioners say that because the Constituent Assembly has not made any changes in Article 370 and just ended just like that, it means Article 370 is not a temporary provision, but it is a permanent provision. Why? Because the assembly did not comment much on that. That is the petitioner's argument against this Article 370. Fine. Now, because now there is no Constituent Assembly, the replacement happened. What replacement happened? Instead of Constituent Assembly, Legislative Assembly of Jammu and Kashmir will take the decision. That means President need to ask the Legislative Assembly. What changes were brought? The changes were brought in 367 via Presidential Order 272. That is one thing here. Fine. So 367 article interpretation regarding 370 clause 3. So I repeat, in this the interpretation of this clause was changed. What was changed? Instead of the Constituent Assembly, it is Legislative Assembly, because it was under President's rule. For 6 months there was Governor's rule in Jammu and Kashmir, and after that what happened? After that President's rule has come. President's rule means of course they have to take the opinion of the Governor of the state. See here, President asking the Constituent Assembly, which is not there. So what he has to do? He has to ask the Legislative Assembly. But now Assembly is not there. Why? Because President's rule is under operation. Now, because President's rule is there, who should the President ask? The Governor of the state. But here even Governor has not taken the decision. Who has taken the decision? It is the Parliament which has taken decision on behalf of Governor. See how the processes are going on here. Fine. If in case you don't follow some of the explanation, please do ask your question in the comment box. I'll be happy to clarify. So what happened here? Because now the modification has been done to this article and this article. So now it makes it easy for the Parliament to now change the special provision. Okay, that is what happens. So on August 3, President Kovind issued second proclamation by operationalizing the Rajya Sabha recommendation. So Amit Shah has introduced this particular recommendation in Rajya Sabha instead of Governor taking the decision. So what happened here? Rajya Sabha has taken the decision. Okay, as per Article 373, President acting upon not the Constituent Assembly, not Legislative Assembly, not the Governor, but who? It is the Rajya Sabha recommendation President has accepted, and immediately he issued what? CO, Constitution Order 273, and told Article 370 ka special status is gone. That is one thing has happened. And 35 capital A also. 35 capital A was what? It was giving powers to the Jammu and Kashmir legislature that they can modify the status of permanent residents of Jammu and Kashmir. There were restrictions on the outsiders with respect to Jammu and Kashmir. They will specify who the Assembly of Jammu and Kashmir specifies the permanent residents of Jammu and Kashmir who will be able to avail the benefits of, let's say, jobs, reservations, okay, property and scholarships, etc. That means outsiders will not have much chance. People said it is violative of Article 14, Article 19, Article 16. As a result, 35 capital A also was held violative of those articles, and this also was rescinded. That means two constitutional orders, 272, 273, these things were passed and the special status of J&K was revoked. So I hope you understood the issues, the heart of the matter here. The heart of the matter being here, President's powers to give the orders to rescind the special status. Hopefully that was clear. And now the same thing as we have just learned. So I will give a brief summary of the arguments of petitioners. What they are saying, it should be a permanent feature. Okay, why? Because here see, the provision gave the Constitution, Constituent Assembly Jammu and Kashmir, the power to recommend the changes to Article 370 until the state's constitution was enacted. That means initially it was temporary provision. Why? Because in 1949, India has incorporated Article 370 and constitution was still being written at that time. That's why they say it was temporary provision, because now it is the J&K Constituent Assembly who should make the constitution of J&K that will remain permanent in nature. And this assembly expired in which year? 57, because by the time the constitution was written, they did not comment on the future aspect of Article 370, which as per petitioners means it is going to be permanent in nature. That is what is the argument. Also, Article 147 of the J&K Constitution says what? Any changes to Article Jammu Kashmir Constitution will require 2/3 of members of the Assembly's consent. Now, the petitioners say the presidential orders violate Article 147 of the Constitution of Jammu and Kashmir. So, please understand the arguments properly, then we'll go to Supreme Court's verdict. Next point, legality of the order. Just now we discussed this point. Our 272 order says it is the president, okay, who will take decision by asking the not Constituent Assembly but Legislative Assembly, which effectively means again, because President's rule is there, even Assembly also is bypassed. That is one the question of the legality of the order, Article 370. And next one, 273 article has completely abolished the status of Jammu and Kashmir as special state. See here, misusing President's rule and making governor as substitute for the elected assembly. Hopefully, at the cost of repetition, I am just trying to make this point quite clear for you, because the legality of the question of this particular decision is actually under scrutiny. Fine. So, President's rule is temporary and meant to be a standard unit. So, let us, for example, what could have been done in this case? Because this decision is very permanent in nature, what was the hurry for the government to put President's rule and not take the permission of the assembly? Even if we say, for example, Constituent Assembly is no longer existing, then why not ask the opinion of Legislative Assembly is the question. That means tomorrow the government can do anything, guys. For example, they can impose President's rule, and because there is no assembly, directly the central government will take the decisions, because President has to act as per the advice of Council of Ministers. It puts the federalism of India into question. That is the argument made by the petitioners. So what was the hurry? Why can't you take the opinion of the Jammu and Kashmir Assembly here? Why again President's rule? And again, instead of governor, it is the Rajya Sabha which has made the recommendation. So this puts some question on the federal status of the states and UTs in India. Fine. And the next point, Supreme Court, what it has told. Supreme Court upheld the legality of both the constitution orders. And what Supreme Court has told? That Maharaja Hari Singh, who has told that Jammu and Kashmir will retain the internal sovereignty even after signing the instrument of accession. That is the argument here. But the Supreme Court has told no. Jammu and Kashmir, once it has signed the instrument of accession, will not be having its own internal sovereignty. That is the point here, guys. Okay, because again, the successor of Hari Singh, Karan Singh, issued another proclamation that Indian constitution would prevail over all the other laws in the state. That means it is in effect of a merger like every other princely state that joined India. Supreme Court has said that even though Maharaja Hari Singh has said sovereignty will be there for Jammu and Kashmir, but Hari Singh's successor Karan Singh has issued another proclamation saying that the status will remain same, the constitution of India will prevail over the other laws of Jammu and Kashmir. That is first argument. Second takeaway, Supreme Court held that Article 370 is a temporary provision, unlike what was, we just discussed the point, right? It should be permanent provision, but Supreme Court told it is a temporary provision here. He took a textual approach, not the context of Jammu and Kashmir accede into India. Textual approach to the constitution, because it marked what? Because already in the part 21, Article 370 was called as temporary provision. That is what is the textual approach CGI has taken. Difference is there between textual and contextual approach. Context was what? That it was the J&K Constituent Assembly which will decide whether this is temporary or permanent. But the CGI has seen the text of the constitution in part 21 and said it is the temporary provision, it is clearly written there. So obviously it is going to be temporary in nature. Okay, and it came because India was in a war-like situation when Pakistan came and attacked Kashmir. So in that time it was temporary only, and later they thought after the situation improves, we will take a decision on the matter. Last point, Supreme Court upheld the both presidential orders as we just understood. The central issue was whether these actions would be taken by the union, assuming powers of the state when it is under president's rule. Supreme Court discussed S.R. Bommai versus Union of India 1994 case, which talks about the president's rule. Okay, in this, there are powers and limitations of the governor under president's rule. The CJI has said that governor, and now in the case of Jammu and Kashmir, because governor's rule was over, now president's rule was there. President can assume all or any roles of the state legislature, and such action must be tested judicially only in extraordinary cases. Because president's rule is there, president is empowered to take any decision. Only in some cases we can talk about the legality of the president's decisions. And relying on interpretation of Bommai ruling, Supreme Court said there is no prima facie case that the president's orders were mala fide or extraneous exercise of powers. That means Supreme Court upheld the CO 272 to 73, guys. So this is the problem. And this is from live law, courtesy to them. Let us see some of the last few points. President's order abrogating status upheld. 370 is temporary provision. J&K has no sovereignty. Okay. And CO 272, that is the legality of this president asking the governor. So here the point is J&K Assembly as J&K Legislative Assembly is invalid. One interesting thing here. Okay. So this is of no consequences. The court held that the president can declare 370 inoperative even without recommendation of J&K Constituent Assembly. That means it was ultra vires. It is beyond the authority of the constitution. That means what? Now, if I say, for example, by a small presidential order, if we can just change Article 367 interpretation, tomorrow government can change the interpretation of any particular article. So Supreme Court here has mentioned that in this CO 272, it is invalid because, okay, it is invalid because, that means see here, even though you may think I told both are valid in what sense? President decisions in both cases are valid. But the specific aspect that changing of the name of the Jammu and Kashmir Constituent Assembly to Legislative Assembly, that is invalid. But the president decision is valid. Difference is that the constitution, okay, empowers the president here, 370 clause 3, that he can modify the provision of Article 370. But Supreme Court has told that it is of no consequence whether it is Constituent Assembly or Legislative Assembly. It does not matter because president himself can make it inoperative even without recommendation of J&K Assembly. This is all criticism here of the judgment, guys, because how can it happen? Because it is violating Article 147 of J&K Constitution. It is also violating 370 clause 3. But Supreme Court took a very different side here. Again, as we all know, all court decisions can be upheld, can be going for judicial review. Supreme Court has doctrine of prospective overruling also. So all these things come into our question, guys. And also, what you can do directly, what you cannot do directly, you cannot do indirectly. That is called as doctrine of colorable legislation. Hopefully, I have given in this particular slide. Okay, maybe it's missing here. So, last point here. Okay, I guess I added somewhere. Maybe it's missing here. Okay, so somewhere it is there in the slide. So, point here is what you cannot do directly, you can not do indirectly also is the argument here. Just hold on. I will try to see if I added it in this slide or not. Maybe it's somewhere, but I am not able to look it. It's okay, it's fine. See, here it is there, fine. Thankfully, doctrine of colorable legislation means what you cannot do directly, you cannot do indirectly. So what the government has done here, because directly you cannot change the provision of the constitution by removing the special status. So what they have done by a presidential order. That is one thing. That means the presidential order route to change this is being questioned in this doctrine of colorable legislation, guys. Hopefully you understood. So I think explanation has been complete. And last point, you can see court did not decide whether the conversion of J&K as state was invalid. Here the CJA was also silent. Whether Article 3 of course gives permission for the parliament to reorganize the states in India. And later an amendment was passed that even union territories can be created. But can an entire state be made as union territory or not? That the court has refused to give any answer on that. That means because the government has told, it seems that we are going to restore the statehood for Jammu and Kashmir as soon as possible. Now we don't know when it is as soon as possible. So again another vague provision is there here, because creation of union territories is fine, allowed as per Article 3, but converting entire state into UT, there the court is silent on this matter and it has not given any decision, because they say that anyhow the government has promised that they are going to give back the status of Jammu and Kashmir as state, but time limit has not been mentioned. As soon as possible was told. Again another loophole here. Fine. And the court has told that please conduct elections by September 30, 2024 next year. Again, this also may not be possible again because it is election commission. Even though delimitation has been already done in Jammu and Kashmir, election commission has next step to do elections there. But this date has been mentioned by the court. But tomorrow, election commission can say that the situation is not conducive to conduct elections, and they can even further expand that, they can also further extend that date. That is also a worry here. But hopefully elections come soon to Jammu and Kashmir and also statehood also. And some interesting point brought by Justice Kaul, because the state has seen tremendous violence and lot of loss of life, and army's role, as the court has told, is to not to fight the external enemies, but not to uphold law and order in the state. So why army is there continuously for a long time? That question also was asked. And whatever excesses, whatever the violence happened in this phase, there should be some justice to those people. So what the Justice Kaul has told in this judgment, that there should be a Truth and Reconciliation Commission, okay, that should be set up to investigate the human rights violations by the both state actors and the non-state actors in the Kashmir Valley since 1980s, when the issue became very prominent there. So there should be a Truth and Reconciliation Commission to provide justice to all those people who lost their lives, property and their livelihood and other aspects also. So this is the key takeaways of the Supreme Court judgment. So the important points we have to summarize here is that the Supreme Court here has taken the side of the executive, that they can modify the provisions of the constitution by presidential orders. This has put the condition of the constitution, like interpretation of constitution, into some kind of in the hands of executive, because executive can tomorrow modify any provisions. So we have to wait and watch where this this verdict will lead India towards in the future, because now the powers of executive has been increased. Okay, so don't get emotional in this particular topic, because Article 370 is a done thing. Personally, if I can speak, people more or less have kind of accepted this point. The only question was regarding the legality of this particular decision. So that is what we have to also concentrate as part of our UPSC exam. Fine. And also Jammu and Kashmir as union territory and Ladakh also as union territory was upheld by the court. Ladakh as union territory, some people have problem because Kargil, which is again Muslim majority province, has been now clubbed to Leh. So Leh and Kargil together, Ladakh union territory has come. That is also a provision, but Supreme Court has upheld this because as per J&K Reorganization Act, Jammu and Kashmir union territory and Ladakh union territory has been brought. The only thing is court was silent on whether an entire state can be called as union territory. Now the government has told they are going to restore the statehood as soon as possible. So let us see what the ramifications of this particular decisions are going to be in the future. So if you have any questions, if you find something complicated to understand, please do post in the comments. I will be happy to clarify. I will see you another day with another topic. Keep watching Amigos IAS. Thank you.